So welcome back, everyone, either from break if you are in the West, or from a quick lunch if you are rather Central and East. We're absolutely delighted to have with us the new Privacy Commissioner of Canada, Commissioner Philippe Dufresne. I will not hide how pleased I am to see the role fall upon Philippe Dufresne because of his eminently relevant background as a human rights lawyer, as general counsel to the Human Rights Commission, and as the law clerk for Parliament, Canadian Parliament. And now it seems to me in an excellent position to advise as an agent of Parliament on how to essentially bring privacy legislation to a new era. And that is really what we are going to talk about today. So welcome, Commissioner Dufresne. This morning, perhaps you have heard or you have been told by your staff, privacy was at the center of almost every discussion, because regulating the internet and enforcing that regulation necessarily involves a form of identification of individuals, but also privacy comes into play in relation to what we've come to call capitalist surveillance, where we want to bring in line online advertising to protect privacy, but then we have the goal to have a free internet. In fact, our next panel will address precisely that. All this to say that you have truly a big challenge in front of you, and we really would love to hear you now on how you will approach it, what you see the issues, and essentially how you feel the way forward is designing itself. So welcome, Philippe Dufresne.
Thank you so much, Chantal. Can you hear me? I just want to do a sound check before I begin. Yes? Okay. Thank you for this kind introduction. And it's great to be here. I'm so grateful to the ICJ Canada. I see some friends, former colleagues along the attendance. So it's grateful. I would wish that it were in person, but that will come. Thank you to Dentons as well for the opportunity to speak to all of you on the subject of regulating the internet while respecting the rule of law and protecting the fundamental privacy rights of Canadians. My remarks will touch upon my current role as Privacy Commissioner of Canada, but also on my previous experience as a Senior General Counsel of the Canadian Human Rights Commission, where I was personally involved in some of the key cases involving the regulation of hate messages on the internet, as was my colleague Monette Maillet, who I'm thrilled to see here. As a former president of the Canadian section of the International Commission of Jurists, I also know firsthand what an important role the ICJ plays in bringing attention to key issues impacting Canadians, including the promotion of human rights and freedoms and the rule of law, both within Canada and internationally, and the importance of having an independent judiciary and of ensuring the appropriate balance between national security and civil liberties. The ICJ's commitment to protecting and promoting these principles is invaluable, and I'm so thrilled to be here today to contribute to this important work and this important discussion. My appointment this last June as Privacy Commissioner of Canada was for me a logical progression in my career as a lawyer and senior executive committed to the promotion and protection of the fundamental rights of Canadians, while at the same time ensuring that pragmatic and important objectives and interests such as public interest and security and innovation were also achieved. This approach also applies certainly to the world of privacy, and finding the right ways of protecting and promoting our fundamental right to privacy while harnessing new technological opportunities will be a key challenge for Canada's institutions and for jurists in the coming years. Technology offers tremendous potential for public and private sector innovation, and that includes the internet, for improving the lives of Canadians. Ensuring that we are able to use these innovations while protecting privacy and achieving other public interest goals will be critical to our success as a free and democratic society based on the rule of law. To do so, Canada's federal public and private sector privacy laws will need to be modernized, both to respond and adapt to these societal and technological changes and to keep pace with legislative developments in other jurisdictions domestically and internationally. The government took an important step towards this goal with the tabling of Bill C-27, the Digital Charter Implementation Act, in June of this year. The bill is a recognition by the government that Canadians need and expect modernized privacy laws. As Privacy Commissioner, I welcome the tabling of this bill, which is an improvement on its predecessor C-11 and on PIPEDA. I look forward to providing my advice to Parliament on how the bill can and needs to be further improved. In doing so, I will apply the three elements of my vision for privacy that I presented to the House of Commons and Senate during my confirmation hearings in June. The three elements are privacy as a fundamental right, privacy in support of the public interest and Canada's innovation and competitiveness, and three, privacy as an accelerator of Canadians' trust in their institutions and in their participation as digital citizens. This vision reflects the reality that Canadians want to be active and informed digital citizens, able to fully participate in society and the economy without having to choose between this participation and their fundamental privacy rights. Canadians should be able to benefit from the public interest and economic advances brought by these new technologies with the reassurance that their laws and their institutions are there to appropriately safeguard and protect their personal information. In short, privacy is fundamental, it supports important public and private interests, and it builds necessary trust. I want to talk briefly about the 2014 R.V. Spencer decision of the Supreme Court of Canada because it touches upon the internet and privacy. As many of you will know, in this momentous decision, the Supreme Court of Canada found that there's a reasonable expectation of privacy in subscriber information held by internet service providers, and that as a result, the police could not request this information without a warrant, even when investigating a serious crime like child pornography. The decision therefore recognized an understanding of privacy as anonymity protected by Section 8 of the Charter. I want to note that my office now, the OPC, which was not my office then, but was under the great leadership of then Interim Privacy Commissioner Chantal Bernier, was a key intervener in that case and was represented by an impressive legal team led by now Supreme Court Justice Mahmoud Jamal and now Ontario Privacy and Information Commissioner Patricia Kosim. All I will say is I would not have wanted to be on the other side of such a formidable legal trio. I believe that this case serves as a good illustration of what I mean when I say that privacy is a fundamental right, that it supports the public interest, and that it accelerates trust. Let me explain why. In 2019, talking about privacy as a fundamental right, the OPC and its international colleagues in the Global Privacy Assembly declared in the resolution that, quote, privacy is a precondition for citizens' other freedoms, as well as a keystone right for democracy and personal and social development. We said that there is a, quote, indispensable link between the protection of the right to privacy and a society's commitment to promote and respect human rights and development. This description of privacy as a necessary condition for the existence of other fundamental rights is consistent with the Supreme Court of Canada's long-standing interpretation of privacy law as having quasi-constitutional status because of the fundamental role that privacy plays in the preservation of a free and democratic society. In Spencer, the court, in the decision written by Justice Cromwell, reiterated the, quote, the strong claim to privacy in relation to information that is at the biographical core of personal information, which individuals in a free and democratic society would wish to maintain and control free from dissemination to the state. So again, this notion of privacy and free and democratic society. The court also added that the understanding of informational privacy as control, quote, derives from the assumption that all information about a person is in a fundamental way his own, for him to communicate or retain for himself as he sees fit. And there, the accent on fundamental nature of privacy. Finally, The court cited with approval the statement from the Federal Court of Appeal that, quote, personal privacy protects an individual's ability to function on a day-to-day basis within society while enjoying a degree of anonymity that is essential to the individual's personal growth and the flourishing of an open and democratic society. This treatment of privacy echoed international law and the inclusion of the right to privacy in the 1948 International Declaration of Human Rights. I note that Bill C-27 contains a preamble that would make explicit Parliament's recognition of the importance of the privacy and data protection principles contained in various international instruments. Treating privacy as a fundamental and quasi-constitutional right means treating it as we do other human rights, as a priority. It means that privacy must be legally protected with a strong, fair, and enforceable legal and rights-based regime, a regime that offers meaningful remedies to prevent and address violations and that acts as an incentive for institutions to create a culture of privacy. Let me repeat that, a culture of privacy. Privacy by design where it is considered, valued, and prioritized. Privacy that is embedded at the outset of innovation, not as an afterthought or regulatory irritant. It means that the collection, use, retention, and disclosure of personal information must be limited to what is demonstrably necessary and proportional, that employees and law enforcement officers are trained about the importance of protecting privacy, and that ongoing monitoring to ensure policies are followed. It means having mechanisms in place that identify and address privacy issues early and on an ongoing basis, particularly when introducing new technologies involving the collection of personal information. And on this, pitch for my office, our business advisory and government advisory directorates are available to consult with organizations and departments and agencies on their data collection initiatives to ensure that appropriate steps are taken to protect privacy. Treating privacy as a fundamental right also means giving privacy an interpretation consistent with the purpose and objectives of the legislation, which can, in the case of PIPEDA, the private sector privacy law, be the promotion of trade and commerce as a matter of federal jurisdiction. It means that in cases of conflict, and these will be rare, between privacy rights and private or public interests, privacy will prevail. I say that these cases will be rare because by creating a culture of privacy and protecting personal information at the front end, we will be able to avoid most conflicts and achieve both privacy and the desired public or private interest. This brings me to my second pillar, privacy in support of the public interest and Canada's innovation and competitiveness. This second element is a recognition of the positive impact of privacy protection and a rejection of the false choice between privacy and the public interest. Just as we can and we must have national security and human rights, and just as we need freedom of expression and protection from hate propaganda, we can and we must have privacy while fostering the public interest, including the prevention of crime. It is not a zero-sum game, and as in so many things, we must reject extremes in either direction. Canada can have a strong and effective law enforcement regime, including online, while at the same time providing a strong and effective legal regime to protect the personal information of Canadians. To make a comparison with the justice system, we would all as lawyers agree that procedural fairness and natural justice in trials are essential. But we also recognize that legal proceedings must be concluded without unreasonable delays and that the cost of the justice system must be managed effectively. We do not look at these goals as a zero-sum game where we're trading off fairness for cost savings or expediency. Instead, we need to work hard together as a legal profession and in whatever our roles in the system to ensure that the fundamental right to natural justice is protected while we achieve the other important public interest goals of timely and affordable justice. I'm not saying that this is easy, but I am saying that it is necessary. In my former role at the Canadian Human Rights Commission, I successfully argued in the Saskatchewan Human Rights Commission and Watcott case before the Supreme Court of Canada that hate propaganda prohibitions and human rights codes could be a reasonable limit to freedom of expression under Section 1 of the Charter. To do so, I put forward a narrow interpretation of the prohibition that applied to messages that dehumanized and demonized individuals, as had been held earlier by the Supreme Court in Keegstra and Taylor. This was another example of the court refusing to find a conflict of rights when rights could instead be reconciled and brought into balance. In Spencer, the director of public prosecutions had argued that recognizing privacy as anonymity would impede the effective investigation and prosecution of online crime. This was another way of saying that it was a zero-sum game between privacy and the rule of law. The court properly rejected this argument, saying that, quote, recognizing that there may be a privacy interest in anonymity depending on the circumstances, did not, in fact, threaten the effectiveness of law enforcement in relation to offenses committed on the internet. In that case, the court said it seemed clear that the police had ample information to obtain a production order requiring Shaw to release the subscriber information corresponding to the IP address they had obtained. The way to avoid conflicts and to achieve both privacy and the public interest is by considering privacy at the front end, not after the fact. Doing so will be more cost efficient and effective, and the costs will become investments that are good for business and good for governments. In a survey earlier this year done by Cisco, 81% of respondents reported returns on their privacy-related spending. Money spent on protecting and promoting privacy is an investment in trust and the security of clients in both the private and public sectors. It is not an either-or proposition. Even in the context of privacy intrusive tools, such as facial recognition technology, my federal, provincial, territorial privacy commissioners in Canada, all of us have not called for an outright ban, but rather for a clear and strong legal framework to regulate its use. This was the subject of a recent report by the Ethics Committee of the House, which recommended a moratorium on the use of facial recognition technologies until they could be reviewed by courts or by my office. I welcomed the committee's report, which confirms and reiterates the pressing need to ensure that the appropriate regulation of privacy impactful technologies such as facial recognition and AI. I noted that the report confirmed the need for critical measures such as mandatory privacy impact assessments and consultations with my office prior to the adoption of creation and use of facial recognition technology, improved accountability and transparency through enhanced oversight and public reporting and consultation, strong and effective legal frameworks to set limits on the use of facial recognition technologies by police, and to ensure that privacy is protected at every stage of the process, and a need for the modernization of private and public sector privacy laws. Just last month, my provincial and territorial colleagues and I issued a resolution on digital identification. In announcing the resolution, I stated that the development and implementation of a digital ID ecosystem is a tremendous opportunity to demonstrate how innovation and privacy protection can coexist. We can all see the benefits of a system that will allow individuals, businesses, and governments to confirm identities and carry out transactions online with a high degree of efficiency and confidence. But we must also recognize that unless digital identity projects and the frameworks that support them meet high standards of privacy, security, and transparency and accountability, they will not be trusted enough to be widely adopted, and those benefits will not be realized. Our resolution called on governments and other stakeholders to build those characteristics into the ecosystem from the beginning. Earlier this summer, I attended the meeting of the G7 data protection authorities in Bonn, Germany. The theme of our meeting was data free flow with trust. And our discussion focused on international data spaces, data transfer tools, privacy enhancing technologies, and de-identification standards. All of these themes support the proposition that privacy and international trade can and must coexist. Private sector privacy law reforms put forward by the government have sought this balance by giving organizations greater flexibility to use personal information even without consent if it was done for legitimate business interests. As you may recall from the OPC's submission on the former Bill C-11, which died on the order paper last summer, my office agreed with that intention if it was done within a rights-based framework in a necessary and proportionate manner and with greater corporate accountability. Some of the tools to achieve both the public and individual interest while protecting privacy include privacy by design, the preparation of privacy impact assessments in appropriate cases, and the regulation and use of de-identified information. Treating privacy as a fundamental right and finding ways to achieve the public interest and innovation at the same time is not only possible, it is indeed a virtuous circle that will generate trust and that will further benefit these interests. This brings me to my third pillar, privacy as an accelerator of trust in the digital economy. When Innovation Minister Philippe Champagne introduced Bill C-27 in June of this year, he emphasized the importance of trust. I agree, but would add that the way to achieve this trust is through the effective protection of privacy. When individuals trust that their rights will be protected, they feel confident about participating freely in the digital economy. This is good for Canadians, good for government and industry, and good for innovation. Yet in our most recent survey of Canadians, more than half of respondents felt businesses do not respect their privacy. How do we restore this trust? Let me highlight 3 ways. First, we need a strong set of public and private sector privacy laws that fairly and effectively regulate the collection, use, retention, and disclosure of personal information so that Canadians know that they're not alone in protecting their fundamental right to privacy. The Spencer decision is an example of this, where the legal system confirmed and protected Canadians' reasonable expectations of privacy. As I stated earlier, our laws need to be rights-based and provide effective remedies in cases of violation. Second, and this touches my office directly, we need to ensure that data protection authorities have the necessary authority and resources to provide not only compliance and protection mechanisms to deal with complaints, but to also play a strong advisory and promotion and prevention role in giving independent and expert advice and input to organizations. A recent example of the importance of organizations obtaining and being seen to obtain independent advice arose in the case of the RCMP's use of on-device investigative tools that can access content as well as activate the camera and audio functions of smartphones without the user's knowledge. In June of this year, the RCMP confirmed to Parliament that it had been using such a tool with judicial authorization, but without having notified my office, despite being required to do so under government policy. Canadians expressed concern about the situation, and the Ethics Committee of the House launched a study into the matter. In my testimony before the committee this summer, I noted that while there may be valid reasons for the use of such tools in appropriate circumstances, the RCMP's failure to consult my office had resulted in a reduction of Canadians' trust. I indicated that it was imperative that a privacy impact assessment be provided to my office in such cases, and that this should be made a binding legal requirement in the Privacy Act. In another appearance this summer before a Senate committee reviewing proposed amendments to the Broadcasting Act, I made a similar recommendation that the CRTC be required to engage with my office when it considers the issuance of orders that could have an impact on privacy. My hope is that in most of these situations, we would either be satisfied with the measures taken, or we would be able to provide advice resulting in course corrections at the outset. What is certain is that the very fact that these consultations would take place with my office would reassure Canadians that their privacy is properly considered and protected. A third measure to restore trust, we need to create a strong culture of privacy where Canadians do not feel that they're being nudged or encouraged to provide more information than what is strictly necessary and proportional to achieve an organization's purposes. We need to make it easy for Canadians to choose the most privacy protective settings and make it clear to them when, how, and why their information is collected, used, disclosed, and retained. Our findings in the Tim Hortons investigation, where the company's app tracked users' locations even when the app was not in use and without the user's knowledge or consent, demonstrates how trust can be undermined when privacy is not sufficiently considered and protected. It serves as a reminder of the work that remains to be done as a society to promote a culture where privacy protection is the default setting and where Canadians have the reflex to always ask why their personal information is being sought. A culture of privacy, with privacy by design and privacy by default. In conclusion, there's no doubt that the modern economy and governments increasingly rely on the value of data extracted through digital technologies, but we have also seen the risks and the harms of technologies with inadequate privacy protections. Canadians should not have to look over their shoulders when using technology. The way forward is through reform of our privacy laws in a manner that recognizes and protects privacy as a fundamental right, while at the same time supporting the public interest and innovation and accelerating Canadians' trust in their institutions and in the digital economy. And with that, I would welcome your questions. Thank you, merci.
Thank you very much. Let me start by saying how impressive it is to see you have such a clear vision, barely 4 months into the position? So yeah. So
almost 5.
Yeah, so that is truly inspiring. There are questions from the audience, so I will go through the first and the second and the third. So the first question is, why do you think privacy by design is not specifically mentioned in Bill C-27, understanding that you are reserving your comments on Bill C-27 for your appearance before Parliament? If you could, as much as you can, say, why would you surmise privacy by design was not expressly included?
Right. Well, and it is interesting, and I have to say, certainly with my current role and my former role as the law clerk of the House of Commons, I certainly would hesitate to put forward intentions or purposes of parliamentarians or ministers if I'm not if I was not involved in those discussions or not aware of them. But what I can say is that, and I've said this to the Ethics Committee this summer, and I've said it today. I view privacy by design and the preparation of privacy impact assessments in appropriate case as being not only important but hugely beneficial to the organization itself. And so that's why I talked about the example today, where the RCMP using what the acronym is audits, using these tools, quite privacy intrusive tools, and not having consulted my office or provided a privacy impact assessment, diminished trust, because Canadians were concerned about these tools were so powerful. They were concerned to ensure that the privacy was considered. And privacy by design and privacy impact assessment does that. It makes sure that there's a culture of privacy, that it's considered in the design. It's always easier to put in place these things when you're designing projects, tools, and initiatives than after the fact. It's like building a structure with accessibility in mind, as opposed to putting accessibility at the end of it. And so this is something that certainly my office recommended in the context of the previous C-11, and I've recommended it in the context of my committee appearances, both in the Senate and the House, with respect to privacy, potentially privacy intrusive measures.
Well, building upon the example of the RCMP, another question from the audience is, has the RCMP submitted a privacy impact assessment yet on the spyware?
We are waiting for that, but there have been good exchanges. There was a meeting between the RCMP and my office. We have received presentation and information, and we have provided them with our input. And so this is what should have occurred before the parliamentary hearings, but it has occurred now, and it is progressing.
Mm-hmm. And if I can just add, in my experience, both as in the Office of the Privacy Commissioner of Canada and now as counsel to companies, privacy impact assessments are actually protective of the organization, because they give the organization the lay of the land. What are the privacy risks? How do we have to mitigate it? What's our action plan? And so it really is, to me, critical to risk management. So I emphatically agree with you that they are critical to protection of the right to privacy. I would like to add that I also see it as protective of the organization. There's another question.
I agree. Let me just jump. I'm sorry. I don't want to interrupt you, but I want to echo that, and that's why I spent so much time talking about privacy in support of the public interest and of innovation. It's really to see that you can be a champion for privacy, and at the same time, and as you are, Chantal, and others, advising private organizations in a way that also supports their interests and also supports privacy. And that's a perfect example of it, where at the end of the day, it's not just about complying with your legal obligations. It's actually beneficial to you and to your clients and to your reputation.
Mm-hmm. And there's another question from the audience. If when you look at how let's say the context of Bill 27 is occurring, do you have any idea, any sense, and of course, nobody is asking you to predict the future, but if you had to say when you think it would be adopted, would you say, for example, that it's realistic that it be adopted before the end of 2023? Do you have any framework that you would put around what you see as a realistic expectation of the adoption of Bill C-27?
It's very difficult to say. We have a minority parliament. What I can say, it's now being debated last Friday at second reading. So that is a positive step. That there is a tabling of the bill in June is positive step. It's now being brought forward for debate. So I don't have a sense in terms of how quickly the House tends to. They will sit later, and this is with my hat of law clerk of the House. The House sits later, and there's always a push towards the end of the December session, and then also towards the end of the June session. But really, one of the things I learned with my time at the House is that time is a very precious and very rare commodity for the House and for parliamentarians. So difficult to say, but it is certainly overdue to have a modernization of both private sector privacy legislation and public sector privacy legislation, which is even older. And so that is something that we have been calling for some time, as have many. It'll be important to get it right, and I look forward to being able to provide my advice to Parliament in this context. And I know that there'll be many others, but I've had a good. One of my early priorities was to engage with stakeholders, both from industry, government, academia, civil society, and so I've done that, and it's been very helpful. And I'm confident that there'll be a good debate in Parliament, as there should be.
Mm-hmm. One question that I have heard from several private companies, they are musing, wondering how your attachment to human rights, to privacy as a fundamental right, how will that impact your enforcement of the law? In particular, they will wonder how much of their interests and operational realities would you take into consideration through that prism of privacy as a fundamental human right?
Right. No, that's an important element, and I mentioned it in my remarks today. Privacy as a fundamental right ultimately means what is the result of it being a quasi-constitutional right is that it will, if there is a conflict within privacy and other interests, privacy will prevail. That's the same thing for anti-discrimination provisions, or it's the same thing with constitutional provisions. But before you get to that, you need to do all the work necessary to avoid getting there. And that's what the Supreme Court of Canada said in the same-sex marriage reference when there was discussion about conflicts of rights between the right to equality for the protection of same-sex marriage and the right to freedom of religion, which was being put forward as an obstacle to that and as, again, a sort of a zero-sum game. And the court, rightly, obviously, I have to say that it's the right decision, that the court's decision at the end of the day found that before you reach the conclusion that there's a conflict, you need to really explore all the other ways to avoid it. And it's only in those rare cases where there actually is one that you will need to resolve it. And that's why you need principles like privacy as a fundamental right for these situations. So it's the last resort. It's not the first resort. And that's the same thing for enforcement mechanisms. I see those as last resorts. They should be used in major cases where there are significant violations. But I see them mostly as very helpful incentives to encourage prevention and discussion and remediation early on. That's the approach that I used to take when I was at the Human Rights Commission, to try to prevent and to understand, I think to the point you mentioned about understanding the realities and imperatives of organizations. that will be a priority. It's something that I did when I was at the Human Rights Commission and as law clerk of the House to the same extent, where we were in a way, I was in a way the Department of Justice to the legislative branch. It's imperative to understand the realities and implications of parties, partners, and certainly regulated entities. And I certainly am, and very proud to be a human rights lawyer and a promoter and protector. But I am also a senior executive. I am also an employer. I am also responsible for compliance with legal regimes and legal obligations. And when I was with the House, I was essentially the chief legal officer. And so I understand the realities and challenges and difficulties and sometimes frustrations for CEOs and VPs and boards of directors to juggle all these many pressures. And I understand and appreciate the value that privacy champions such as yourself and private sector counsel, in-house counsel bring to the table. And so this is and I've reached out to stakeholder and industry early on in my mandate as privacy commissioner. As you say, this is my fifth month, but it is important. We need to understand those realities. And I can say with a smile that I have been, in a sense, in your shoes vis-a-vis my now colleague, the ethics commissioner, Mario Dion, because he regulates members of parliament. And I had occasion to appear in parliamentary committees to comment on some of his proposed strengthening of the ethics code for members of parliament. And my job there was to put forward the realities of parliamentarians and say, look at how they operate and look at what the impact will be on about these rules that you put forward. It may make sense in theory and in principle, but there may be some unintended consequences on the reality of this important function, which is the role of a parliamentarian. So it's a similar approach that I will be bringing as privacy commissioner.
You and I have had this discussion before, and I came out of it with the description of your approach as being pragmatic. Is that a fair description, would you say? A pragmatic approach?
I think so. I would add principled and pragmatic. So again, it's not an either or proposition. I am very firmly committed to the principles, and as you have seen, I have been from my confirmation hearings onwards, and in every presentation, I start off with privacy as a fundamental right, and I spend a lot of time on that because I do think it is essential. And I know that there have been some questions raised about whether it should be so or whether there are concerns about that. I am firmly of the view that it is and it should be so. But I do not see that as being contradictory to a pragmatic approach that also makes sense and that also will be supportive of government's needs in terms of public interest and industry's need in terms of innovation and competitiveness.
So let me turn to another question from the audience, and I will read it to you to be faithful to it. You described trust as one of the 3 pillars of privacy. You also described a culture of privacy as an important part of promoting trust. What concrete measures, activities, or tools do you see the OPC using to assist, motivate businesses in developing a culture of privacy?
Well, we need to be present and open and available with businesses and with government. So I talked about the need for privacy impact assessments and consultation with my office. We need to be able to deliver on that, and we will need to be properly resourced to be able to do that. We have a business advisory section, directorate in Toronto. We have a government advisory section, and we are available to advise. We need to be trusted to do so, and I've had discussions with stakeholders in industry about why there has not been as high a take up as we would have wanted to see of those services, and concerns about how do we manage this with our compliance functions, and can organizations do that while managing their risks? And I absolutely understand that. So we need to have that service. We need to be able to provide insights and inputs to assist Canadians, individuals to know their privacy rights, organizations how to put them in place, how to correct, how to redress. I really see the twin roles that we have in terms of protection and promotion working together. I want the promotion to come first and the protection to come if necessary, but ideally we are able to assist and to publish guidance documents. There's going to be certainly lots of, again, I don't want to presume what Parliament's decision will be, but in its current form, there is a regulation making power under C27 to provide certain more precision on certain concepts. There is opportunity for my office to provide guidance. So that's very important. I think we need to be, and I will do this myself as Privacy Commissioner, publicly communicating on the importance of privacy. And I mentioned in my confirmation hearings in the Senate the importance of children and youth. This is something that is in C27, but I do think it is important that we communicate with Canadians of all ages, but certainly in particular teenagers and minors about privacy, about its importance. They are living in the world where they're using digital tools more and more. They are being asked to share information more and more. So it's important for them to have a good understanding of what the implications are, and that they value this, and that they be aware of what it means. And so all of this, I think, and again, it was striking to me to see how both with respect to the RCMP's use of tools on device investigative tools, but also in terms of the mobility tracking, in terms of the public health, the pandemic situation, the fact that there hadn't been a meaningful consultations with my office was a missed opportunity in generating trust for Canadians. And so that's something I want to make sure that we can certainly do our part as the OPC.
So building on that, if we look at a possible formalization of, yes, the new powers that Bill C27 would give you in terms of guidance to companies, as well as your existing business advisory program and your own approach, I would like to put to you whether you would envisage formalizing this approach in a sandbox model, a bit akin to what the United Kingdom Information Commissioner's Office did, whereby a company can bring to the sandbox team, so to speak, their project. The ICO will say, these are the privacy issues we have, these are our recommendations, very concrete. The company is able to truly put forward its intentions without fear, because the sandbox is truly a safe space for that. They know that coming to the ICO with a project that the ICO has issues with will not lead to an investigation. So that sandbox model has been adopted by other, in fact, in Canada, the financial regulators use the sandbox model. Is that something that you would consider? Is that could be envisaged to formalize it in some way?
Absolutely. I think this is something that has been explored elsewhere. It's something that offers many benefits. I think the to some extent there's some elements of that in C27 in terms of having us review privacy management programs or certification codes. But there is this issue that you highlight in terms of doing so. How do you do that with the certainty that this is not going to be usable in compliance functions? So it's certainly something worth looking at. I think one of the issues that is top of mind for me in looking at initiatives like this is really the concept of resources. They're finite resources for my office. They're finite resources for government and for Parliament as a whole. And so that is something that would be beneficial, but we want to make sure that there are sufficient resources overall in the system before we can do this.
All right, very interesting. I would like also to put to you a discussion we've had this morning with respect to a notion of the collective right to privacy, specifically the regulation or not of anonymized information. And we're talking where the data, the substantive information, is truly irreversibly severed from any identifier. And so Dr. Teresa Scassa was mentioning this morning, saying we need to pay attention to that in the name of a collective right to privacy that she would say needs to be addressed further. I would love to hear you on that notion of a collective right to privacy.
Well, I think that this is something that we have been hearing more and more, and it's been raised also, and this may well have been mentioned earlier today, but it was raised in the context of indigenous peoples and consulting indigenous peoples with respect to privacy law reform. I understand this is happening with respect to potential Privacy Act law reform for public sector. And so looking at these concepts, I think it is a question worth asking, to seeing certainly the focus of privacy legislation has been in terms of identifiable individuals, so at the individual level, and certainly need to make sure that we get this right. And definitions of anonymization and de-identification, I think, are built on that premise of ensuring that you cannot identify an individual, or that you're mitigating the risk as much as possible. But it is a good question to ask as to whether there may not be the ability to identify specific individuals, but are there other types of harms that will nonetheless flow from this, with respect to identifying certain groups of individuals and drawing some conclusions. And so that could give rise to a number of questions, from privacy questions to equality questions. And so that is, again, without commenting on the ADA part of Bill C-27 in terms of proposed regulation of artificial intelligence. But that is one of the concepts being put forward in terms of looking at harms, including human rights harms, and in the decision making.
So possibly going outside of the realm of the right to privacy, which attaches to individuals, but not forgetting that there are human rights issues beyond the right to individual privacy. Another question has come up from the audience. I'd like to read it to you to be faithful to it. The OPC has historically highlighted non-compliant activities by organizations. In the future, would the OPC be willing to highlight companies that do privacy well and have a culture of privacy to encourage engagement? In other words, could there be a carrot as well as a stick?
I try. I usually don't say this is a great question, because I don't want to suggest that the other questions that have been asked before or after were not great questions. But I will say this is a great question. In here, I am biased on it, but I have stated this in my confirmation hearings. I think both in the House and in the Senate. It's certainly something I believe in, and it's part of the element of trust as my third pillar of privacy. I think generating trust of Canadians in their institutions also includes Canadians seeing not only when there are breaches and concerns and violations, but also seeing when there's good protection and good action, good promotion and prevention. I think it is important to highlight this, and I think it's important for me personally as Privacy Commissioner, but also for my office, to do so, because our voice is credible and has an impact. And so certainly important to call out concerns, and we do that. But I'm a big believer in incentives. I want to put incentives in the right directions and encourage behaviors. I believe that in-house counsel and privacy advisors everywhere can be champions of privacy. And so we need to give the incentives, give the arguments when you're convincing your clients or your organizations to do the right thing. And I've been in those shoes. It helps to be able to say, well, not only are you going to avoid this potential negative outcome, but also you can have good outcomes. And perhaps to get the good outcomes, you need to do a little bit more than what you need to do to avoid the bad one, but it is worth it. And so that's certainly something that I will want to do.
Thank you. Another question that comes out of Dr. Teresa Scasa's presentation this morning was, what is the future of cooperation between federal and privacy commissioners provincial after there is the creation of a tribunal? Do you see that having an impact on the collaboration between yourself and your provincial counterparts?
Well, I think that the collaboration with the counterparts is excellent. It will continue to be excellent, and it needs to continue. I've heard from industry stakeholders about how beneficial it is when we can work together as regulators, and we've done joint investigations. As you know, we've done joint statements. I talked about some of them today. We did one on health and making sure to protect health information and stopping to use the fax and using more secure and modern technology. So that's important. It's beneficial for everyone. I know that, and certainly looking back at C11, there were discussions about the tribunal and the proposed tribunal and what the impact will be. Obviously, I won't comment specifically on that because I will wait to make my comments and recommendations to Parliament before I make them publicly. But what I can say is that we will always find ways to work together and to coordinate. And if there is a tribunal or whatever review process, there are review processes in the provinces as well with the court systems. So it's something that we'll need to manage. But it has been raised by my office in the context of C11, the risk that if one process, whether it's the federal one or others, becomes so much less advantageous or quick or helpful, then that may raise challenges in terms of interoperability. So that's certainly something that we have been pushing and supporting in terms of ensuring that the regimes are interoperable, that they can work. That's important in Canada. It's important internationally as well. When I was in Bonn with my G7 colleagues, we talked about data free flow with trust. Obviously, that touches upon the issue of adequacy. It's important to Canada maintain adequacy under the GDPR, that our regimes are considered to be robust. And to me, I see this as the contrary of the lowest common denominator. It's the highest common denominator. We want to push towards the best regimes, but this idea of making sure that they can work with one another, very important. And I would add, so not only in Canada do we need to do it between federal, provincial, territorial, not only do we need to do it internationally, but we also need to do it with public-private relationships. So we're seeing more and more public-private partnerships between the government and the private sector in the delivery of public service. I think that's a good thing from a standpoint of innovation, and there can be benefits to taking the best of both worlds. But we run into challenges if the legal regime for public sector privacy is so different from the one for public sector, or vice versa. So it will be important, and I've said publicly that I hope to see private sector modernization happen, and for it to be followed shortly thereafter by public sector modernization, which is even more overdue if you look at the years. The Privacy Act is 40 years old.
Another crosswalk of cooperation that is created in Bill C-27 is between yourself and other non-privacy regulators. And this morning, Christopher Parson in his keynote mentioned the issue of competition law with this agglomeration of companies leading to data accumulation with the privacy impacts that we can imagine through the potential of triangulation of data and therefore very precise profiles. So then the question is, how do you see yourself cooperating, for example, with the director of the Competition Bureau? How do you find that appealing? Is that, in your mind, the right way to go? And if it is, then how do you envisage it?
I think that this is something, it's a very important topic. There are more and more issues of intersectionality between privacy and competition, privacy and broadcasting. So these situations arise where you may have issues where is privacy being used as an anti-competitive measure, vice versa. So is there an opportunity to work together? So this is something that I will look forward to doing within the confines of the legislation that we have. And so it's important to review that, but where it can be done without prejudice to the parties, without prejudice to confidentiality. And this is something that I was recently discussing with the Senate committee on the new C11 on broadcasting and the regulation of internet streamers. There was discussion with the Senate committee about privacy implications when the CRTC would make orders to broadcasters with respect to certain potential algorithm use and so on in order to recommend certain content. And so there you have the intersection of broadcasting and privacy. And so there is a mechanism in the Broadcasting Act for there to be interventions in CRTC hearings when they're considering orders. I've indicated that's something we would explore as an ability, but certainly an important topic. And we are more and more in an interconnected world, whether geographically in terms of technology, but also in terms of legal regimes. And so it's important that we, as much as we can coordinate those things. It's better for the evolution of the law, but it's also better for the regulated entities who can have it dealt with in a consistent manner.
Thank you so much. Sadly, we have come the top of the hour. You have been so generous, so insightful, so open. This truly bodes well for your term as Privacy Commissioner of Canada and for Canadians. And so thank you very much. And we look forward to hearing you before the House on Bill C-27 and hearing you throughout the next 7 years, guiding the protection of the right to privacy in Canada. Many, many thanks.
Thank you so much, Chantal and colleagues. Great to be here.
Wonderful. I turn then to Amanda Branch, who will moderate the panel on regulating advertisement online and yet keeping a free internet. So over to you, Amanda.